A British Columbia court is set to hear a dispute over the will of an 84-year-old woman after she left nearly her entire estate, worth around $1 million, to an escort. CBC's Liam Britton is on this story. And Liam, first of all, tell us the basic facts in this intriguing case.
Intriguing is right, Ian. I mean, they're legal soap operas. This one's worthy of a daytime Emmy. So basically, this woman, Janet Henry of North Vancouver, she passed away in 2021. No surviving husband, no children. Even her sibling had predeceased her. And over the course of about 10 years, she had written 4 wills. The most recent one was written just about 4 months before she passed away in November 2021. And it left all of her money to a man named Simon Garston. And as Simon Garston is identified in court documents, he is a male escort. A judge noted that he provides companionship and sexual services to women. And the judge also noticed that Henry apparently enjoyed retaining and paying for the services of various male escorts. So over the course of 8 months, they spent about 7 nights together in her home. But her family alleges that, or Henry's family alleges that this relationship was much more intense than that. Especially spelled out by text messages over WhatsApp and other forms that they allege show Garston was more and more inserting himself into their aunt's life and it being in a position of dominance and control over her. And so they allege that this is undue influence on that will, and they want him taken out of the will, and the niece and nephew want to split Janet Henry's inheritance.
Yeah, so as you point out, they're no close relatives. There's this niece and nephew in Australia.
That's right, yeah, Australia.
And so now they are claiming that there is this undue influence that the escort had on this woman, and so her will should be invalidated because of that. What about the gentleman who is actually named in this will? Well,
Simon Garston, also allegedly known professionally as Sam Gaines, is denying any kind of wrongdoing. He says that he and Henry never discussed her will. He says, in fact, this kind of painting of her as someone who's vulnerable or isolated is not true. She's an independent person, a businesswoman. And he says that, if anything, because he was at times financially dependent on her, she was the one with more authority in the relationship. And so he argues that the will benefiting him should stand. Now, there's also one other player in this story. A person named Douglas Wilson, an old friend of Henry's, was the beneficiary of a previous will written 6 months before the latest one. And he says, basically, if the Garston award is invalidated, it should be him who gets the money. So a judge has ruled that a trial is worthy of proceeding based on especially the text messaging evidence, Ian.
Yeah, it is such an extraordinary story with so much detail. And if you want more of that detail, Liam's story is posted on the CBC News site, and there's a link there to the court decision. At this point, the court just saying this hearing can go ahead, so not a lot of detail, but your story certainly has all the pertinent details. So, Liam, thank you very much.
Thank you, Ian.
Okay, so this is a case that is not your typical law case, and so we're kind of curious about some of the issues involved. And Candace Cho has been kind enough to come here. She's a principal lawyer at Onyx Law Group, and you've been waiting through most of the show to talk, so I appreciate you coming down to our studio and talking to us. This idea of an older person who hired a sexual escort, which is not illegal, and then rewrote her will to include the escort. And now you have these 2 distant relatives in Australia who are contesting it, and a former trainer of this woman also contesting it. To me, this all seems really unusual. To someone like you, an experienced wills and estates lawyer, how unusual is this?
Well, I think even for me, who's seen a lot of these types of cases, it's still more on the unusual side, yeah. For sure. I haven't seen a fact pattern quite like this. But I think what's really interesting here is an intersection of different societal views. At first blush, you might think, well, of course, this is undue influence. Of course, this is elder abuse. But is it really, when she was independent and I don't know if there was no evidence reference of incapacity of the woman.
So let me just jump in and kind of, let's review what we're going to zero in here on in terms of the issue. She's an adult. She makes her choices about her lifestyle. If she writes a will, and if she's of sound mind and she wasn't coerced into writing the will, then the court would respect that. So on what basis might this will, for these 2, the niece and the nephew and the friend in Australia, if they are to prevail here, what do they have to prove?
So what's been pleaded in the notice of civil claim by the niece and nephew is at first instance, a presumption of undue influence. So relying on Section 52 of the Wills, Estates and Succession Act, they are alleging that that their aunts and the escort were in a relationship of potential dominance, where the escort was in a position where he was dominating her will, a potential relationship. And the way that it works is that once that relationship is proven, then there's a presumption that there's undue influence. You don't actually have to prove actual undue influence. And then the onus then shifts to the escort to prove there's no actual undue influence. And if he can't prove that there's no actual undue influence, then the gift to him gets set aside. So what's interesting in here is that the niece and nephew are not actually applying to set aside the entire will. They're only applying to set aside the gift of the residue, which is the bulk of the estate, to the escort, because they are actually contingent beneficiaries of that gift. And so if the gift fails to the escort, it automatically goes to the two of them. And they want this to happen. They don't want to set aside the whole will, because if the whole will gets set aside, the prior will becomes in force, and they're not beneficiaries of that prior will. In fact, it's the former personal trainer of the deceased.
This really is complicated.
The former personal trainer who's actually the residual beneficiary.
It sounds like an exam question, doesn't it? Like
It does.
It's hard to believe it's actually a real life situation. So I know you're not acting on this case. You haven't gone through the evidence, but give me an example of what the niece and nephew, what kind of evidence they would have to point to in order to show that there's been undue influence.
Well, I have actually reviewed a bit of the evidence.
Okay.
I have reviewed some of the affidavit material and the text messages.
Okay.
So, and that's typically where you would go.
So text messages.
Text messages and some of the stuff that you put up on the screen, actually. So you kind of you have to look at, each case is different. So you need to look at the actual quality of the relationship between the two, and does it seem like one person is influencing the other? You also look at other red flags for undue influence. So was this person isolated? Did they have any other friends and family that could easily access them? Or was there a sudden change of behavior where suddenly they can't be reached? You need to look at whether or not there has been some type of cognitive decline that would show some vulnerability, whether they've become reliant on the other person to provide caregiving or fulfilling other need for that person.
But there's also like the sort of cultural baggage here that, I feel like a court maybe 30 years ago would say, oh, an older woman who's been taken advantage of by an escort clearly is the victim of undue influence. But there's another way of looking at this, especially in 2025, that she is an adult, she makes her decisions. It's not about a moral judgment of who she hired. And if she was of sound mind and body, I don't know if they still use that phrase, but if she is, she can write the will the way she wants it.
Absolutely. I mean, that's the concept of testamentary freedom, right? And any adult who has capacity to manage their own affairs, basically any adult over the age of 19 is presumed to have capacity. And the concept that comes from England or origins, the Commonwealth, is that you have testamentary freedom. You can give your estate to whomever you want, be it the SPCA, be it to your children, or be it to a male escort. And in her situation, she actually owed no legal or moral duty to any close relatives. She had no spouse and she had no children, not even grandchildren. And so is there anything wrong with her deciding to give her estate to somebody that she had the closest relationship to, who just happens to be an escort?
There is an asterisk, and I won't go too deeply into this, but we do have the Wills Variance Act here in British Columbia, which if she had a spouse or children, might have opened the door to making changes.
Yes.
But we don't have to deal with that now. Maybe the next case you and I talk about.
Absolutely.
Okay, thank you very much. Candace Cho is a principal lawyer at Onyx Law Group. Thank you very much.
Thank you, Ian.